What are the three most common issues that we find with suretyship agreements? Now, the use of suretyships are commonplace in the South African landscape, especially when it comes to commercial transactions and property transactions. If you're contracting with a company, more often than not, you would ask the owner of the company or the director of the company to sign in his personal capacity in order to cover the debts of their company. And this is called a suretyship agreement. Now, the problem that we experience is threefold. Now, the first and primary problem, and this is the biggest one, is the failure of parties to adhere to the formalities. What does that mean? So remember, a suretyship agreement isn't just governed by a common law. There's actual legislation in place that requires that the suretyship agreement be in writing and be signed by the parties. So this already creates difficulties, especially with the use of email and digital signatures, because when legislation requires that documents be signed by the parties, these need to be advanced electronic signatures as defined in the legislation that exists around that. So very, very important to realize that if you're trying to get someone to enter into a suretyship agreement to make your life easier, please just get them to sign an original in wet ink, as we say, by use of a pen, and to hand this over to you. It is the safest way of doing it, because then you know that there cannot be any formal issue with this agreement. An email that's simply sent to you promising to cover somebody else's debt, unfortunately, does not comply with the legislation. You may find yourself with a void suretyship, something that you cannot enforce. Be very careful with that. Now, the second issue that we have with suretyships is when the clauses of the suretyship aren't definitive enough. Now, what I mean by this is one has to ask the question whether the suretyship is only supposed to cover certain debt, whether it covers ancillary debt, whether it covers future debt. And this is one of the problems, is if the suretyship isn't definitive enough, remember, the courts will interpret the agreement in favor of the surety. They have restrictive interpretation. So one cannot superimpose or read in to this agreement that it includes something that it really does not. So it's very important to define in the agreement to what extent you want to include this cover. So as an example, for ancillary debt, if we speak in a suretyship agreement, simply that the surety is going to cover rental, as an example, a rear rental. Unfortunately, this wouldn't cover any other ancillary costs, such as legal costs in the collection of rental or damage to the property or whatever the case is. So it is very important to define exactly what debt you're looking to cover. Now, this leads me to the third problem, which unfortunately is when the primary agreement is somehow changed and provision for this isn't made in the suretyship agreement. So what happens here? Well, take for an example a situation where a surety signs in favor of a debtor for a period of, say, a year. Now, all of a sudden, between the debtor and the creditor, so the two parties to the main agreement, decide that they're going to extend that agreement by 1 year. Now, the problem here is that the creditor, you, be it a landlord or a seller or whoever, doesn't realize that unfortunately the suretyship is not going to automatically extend for that period of extension of the main agreement. So if you look at a lease as an example, if I as a landlord enter into a lease agreement with a tenant and somebody signs as a surety, let's say, a colleague at work signs as surety on this tenant's behalf. Now, I renew this lease agreement and I assume that the suretyship will cover me for this renewal, but it won't. So you have to be very, very specific in the suretyship agreement that it will also extend or apply to any renewals, or you need to ensure that a new suretyship is signed. So be very careful with this. If the main agreement changes in any way, if it's amended, if it's extended, if terms are deleted, if there's a compromise of debt, remember that your suretyship may not necessarily align with this. So it's very important that you as a creditor, somebody who is owed money, ensures that this form of security, the suretyship, is kept in place, is kept valid, is kept enforceable and applicable to the debt that's actually due to you.